The next bill is going to be heard informationally only. So that means no formal committee action will be taken, but we will discuss the bill and hear testimony as we normally would. So thank you for the informational presentation, Representative Green. And whenever you are ready, please present House File 1999 informationally.
Thank you again, Chair Jordan and Chair Bennett. I appreciate the conversations we've had. So I would like to just refer members to the House File 1999 handout. It's like a DE2, I think is what it's labeled. This bill has, it continues to evolve through conversation, which I really appreciate. So as a former school board member, I have had a front row seat to this growing issue for many years. So we are going to talk about data requests. I want to make it super clear that the public has the right to request data from a government entity, no matter what the topic is. Access to that data is really important, not only just for transparency, but also for the integrity of what it means to have open government. So what we've seen in recent years is that Minnesota Public Schools have received an influx of data requests. And that in itself is not an issue, but what is an issue is that it's been quietly putting a significant strain on valuable school resources. So what is a data request? Because unless you actually hear how it actually works, it's hard to actually figure out, like, what do you mean data? What does that look like? So I'm gonna give you an example. Let's say Mr. Winbird wants to know what training teachers are required to complete every year. What are the teacher training that goes on every year? Mr. Winbird would then have the right under the Minnesota Data Practices Act to ask the district for that data. And the school district, as an open government entity, has the obligation to collect and provide that data for inspection, and if asked, copies of that data. If the request is large, Mr. Winbird would then be also required to pay for copied materials. So what's also important to note is that Mr. Winbird could choose to request the data anonymously if so desired. So what's the issue? The issue is all in the nuance and what I like to call non-serious requests. And here's what I mean, and these are real examples now. One of our metro area districts received a data request from a nondescript email address, anonymous at gmail.com. The district did their job, prepared the data for anonymous for inspection, but then the data just sat. No one came to inspect it. The cost, $6,000 in district staff time. They reported 4 of these non-serious request incidents this past year. Another example from a smaller rural district. A request came in, district carries out their due diligence, prepares the data, and again, nothing. The unknown source never showed up to inspect the data. That cost they estimated at $7,000 in staff time and resources. So it costs money to respond and to prepare the data. And it's extra challenging if the request is large in scale, if it's nondescript, or if it needs redacting of personal data. So what does this bill do? House File 1999 is working to find that middle ground between open government and accountability. Accountability both for the authorizer and also the requester. And I think it's really imperative that we strike the right chord here. An element of this is the training and understanding at the district level. That's an imperative piece of this puzzle, and how we train and how we districts understand what you can and cannot do within the Data Practices Act. I've been working on solutions on this. Well, I've been started looking at data requests back in 2017, but most recently, since I've been elected, I've been working with the Minnesotas for Open Government group, otherwise known as Mingoji, with Don Gemberling and Rich Neumeister, who we've heard from already and we'll hear from again, Matt Engling as well. And then I've also worked with the Minnesota Newspapers Association. Free press is a very important issue to me and something I want to make sure that we don't jeopardize with this bill. I've talked with school district leadership and organizations. I've talked with colleagues. Chair Liebling and Chair Scott over in Judiciary have been very helpful with their comments. I met with Rep. Bakeberg this morning about this as well, an issue that he's seen in his district as a principal. And so here's where we've landed. What this bill will do, where we are, is that districts will be able to offer requests for inspection. And then if the requester does not show up for the initial inspection, that data request is closed. And then the inspection, and inspection is done in person. And so it really is a way to put in statute a little bit of accountability so that we know when a request comes in that it's a serious request. The one thing too is I think that this bill then would hold school districts harmless from the non-serious requests. I think it helps to manage the large and complex requests more efficiently. The other thing is that the requests that are abandoned right now also strain the school system, anonymous or not, and allowing the people who really need the data, it gets in the way of that. And then also what we've been able to do is really extend this beyond school districts. So I know this is an ed policy, but one of the things we've really been able to work through, because this is an issue we're seeing in the county, the state auditor's office, across the board with government entities, it really does address that issue as well. It's a bonus to this work, and I think from all the feedback. So I wanted to also bring up, if you guys will look at your document, one of the two pieces of feedback that Chair Scott and I spoke about with yesterday. One is she would like to add in some language, which I think is a fantastic addition, is that the responsible authorities would need to provide the requester at least 5 days' notice to inspect the data request, or expect their data request. I think that's a great add. I think it adds accountability both to the authoritizer. I don't know if that's a word. I might have just made that word up, authoritizer. But I'm going to go with it. I really like it.
Go with it.
And then also the requester as well. The other piece that I would love feedback on, if anybody has it, is the first sentence in that amendment. It talks about that we may be able to provide data on a rolling basis to a person under this subdivision. And that rolling basis is language that I've gotten some feedback on, that it might feel a little bit restricting for someone who's requesting it, that even though in law, you can roll out that data request, but putting it in statute, there's some hesitation there, so.
Thank you, Representative Green. And we do have a few testifiers. First on my list is Matt Ailing from Minnesotans for Open Government. Welcome to the committee. Please state your name for the record and proceed with your testimony.
Okay, thank you, Madam Chair, Representative Green, members of the committee. My name is Matt Ealing with Minnesotans for Open Government. We're a nonpartisan, all-volunteer nonprofit focused on public access to government information. I'm here to speak in support of the amendment that Representative Green is proposing to HF 1999. First, we'd like to thank Representative Green for her hard and detailed work on this amendment. We think it improves the bill and addresses the issues that we had raised to her about the underlying initial bill. This can be a difficult area of law, and we have been impressed with Representative Green's engagement to make sure this comes out correctly. So thank you very much. I want to speak briefly about the technical effect of this amendment. This amendment really codifies existing commissioners of opinion data practices opinions and guidance about how to deal with large data requests and puts it into statute for a point of reference. Large requests are contemplated by the Data Practices Act as recognized by the Minnesota Supreme Court, or excuse me, the Minnesota Court of Appeals, in Webster versus Hennepin County. Our guidance as an organization to data requesters is always to be as specific as possible, try to get at the sort of the nugget of what you're trying to request from the data provider so that you avoid overbreadth and scope. But sometimes we do recognize that large requests are necessary. You can look at the media requests that were made after the I-35W bridge collapse, for instance. Very large requests, so there is a time and a place for those. And so because of the fact that these large requests sometimes come in, the Department of Administration has issued guidance over the years on how to respond to these large data requests, essentially by breaking them into components and having requesters either inspect or collect copies for each component, and then having the data providing entity, the government entity, move on to the next stage of that request. And so that's the process that's in the amendment language, and we think it's good to have this as guidance in the statute, because we're always surprised by, we run into people who don't understand that you can already do this as a responding government entity. So it's helpful guidance both for the government entity and the requester. So I'm happy to take any further technical questions, and I'll stand by if anyone has those. Thank you for the time.
Thank you, Mr. Ealing. Next on my list is a remote testifier, Superintendent Elsad from Owatonna. Are you with us?
I sure am, thank you.
Great. Welcome to the committee. Please state your name for the record and proceed with your testimony.
Yes, my name is Jeff Felsen. I'm the very proud superintendent for the Owatonna Public Schools. Thank you, Chair thank you, Chair Bennett and Chair Jordan for this opportunity to speak today, and for Representative Green to bring House File 1999 forward. I am the superintendent, have been serving as superintendent in Owatonna for 8 years. I collected some data in regard to this particular legislative action. And over the last 3 years, the Owatonna Public Schools have received 12 anonymous data requests. Out of those 12, 9 of those requests became abandoned. We took time to gather the data, but yet those that requested never showed up to view or inspect the data. That comes with a price tag. With all of those anonymous requests, it cost the district $40,000 to put those items together. Of the $40,000, $30,000 was in relation to the 9 that were abandoned. So $30,000 of our taxpayer dollars were not used because of the abandonment of that request. I would add furthermore that, as the previous testifier commented, these requests can become rather large and onerous. We had a most recent request 3 years ago that cost the district in excess of $400,000 to collect and redact the data necessary for the reviewer. This computes, for those that are in all of you understand education, that this computes into 4.0 FTE. So we, in fact, were not able to hire 4 teachers as a result of this data request. I couldn't agree more with transparency. We want to be transparent and responsible to our taxpayers and constituents. We also respectfully ask that those constituents are responsible and understand the onerous action that it takes for a school district to compile the information, and we would just ask that they then take the time to inspect it. Thank you again, Representative Green, for bringing this forward, and I would stand ready for any questions that the committee might have.
Thank you, Superintendent Elstad. Last on my list is Rich Newmeister. Welcome to the committee again, Mr. Newmeister. Please restate your name for the record and proceed.
Madam Chair, for the record, my name is Rich Newmeister. I've been making data requests since I've been 15 years old. I'm 7 decades old now. Before the Data Practices Act, I was asking many questions of Independent School District 625 and Superintendent George Young, because I was a member of a very active student group during those times. So I'm familiar with data requests and the impact, and I've helped many of your constituents, either directly or indirectly, by teaching programs. I get calls from all across the state and helping people. So the first thing you got to understand, the intertwinement of government institutions with our lives. Government has made more and more intertwined with our lives, so there will be pushback, wanting to ask more and more, why, how come, why are you doing this, whether it be individually or a policy. So there will be more data requests. The thing is, and as Representative Green indicated, and as the person from Owatonna, yes, they do get anonymous requests, and they can cost. But for 50 years in law, there's been training, there's specific dynamics shared with independent school districts and other government entities how to handle large requests. One of those first things is to take a breath and say, okay, what's the scope? How are we going to do this? You don't have to all of a sudden get all the work together. Come on in, Anonymous. The law has been flexible for decades, where you can sort of say, okay, this is a big deal. We can't drop everything. Let's do a little bit at a time. So that goes to my first recommendation that you, Madam Chair, and Chair Bennett may want to do is put in a writer. Because again, Don Gemberling made a great statement about Representative Green, listened, engaged, a fast learner. And I also doubled that comment as being one of the unique people that on this kind of issue at first, so I applaud that. And as we have had our colloquy since I first learned about this 12 days ago, one of the suggestions that I made is put a rider in for education purpose as following. I suggested to her to do a mandate that school districts have, hey, let's not put mandates. But what you can do is a rider, because under Chapter 13073, Subdivision 4, the Department of Admin, who's responsible for training, and they get $500,000 to do it, they do public sector training with school districts. It's even mentioned. So if you put a little rider in that says, we direct the 13, whatever, and it has to be placed in a certain place, here, education, that they do 2 or 3 programs over the next months for all the school districts of Minnesota. So that when they get that anonymous request for everything under the sun, or they get that request from Rich Neumeister that wants 15 years of teacher discipline records, which I have done, they'll know how to handle it rather than, oh. And with the Owatonna situation, if you go in more into it, a lot of it was paid for by attorneys. As you know, there are special attorneys who specialize in school district law, school board law. But if folks were properly trained at the front lines, you wouldn't have to give everything to the school or the special attorney of Knutson or whoever it might be, and your costs are down. The thing that I want to just talk about, and as you know, as Representative Green has been engaged, and I want to thank you, Representative Howard, for your thank you for us folks that we're working, because it's a treat. If you look at the language, it's that first sentence that I have some concerns about. Representative Green knows very specifically my concerns are, because also knowing FOI laws across the country, I've never seen a rolling production or basis put into law, which can cause trouble and concerns. And she has that in detail. If she wishes to share that as part of the discussion, that's her choice. But there's other things that could be talked about. So I'm here just to sort of say, I like the amendment, except that one sentence. And I want to thank everyone. And I'm very much obliged.
Thank you.
Thank you for your testimony. I have no other testifiers signed up, so we will move to member discussion. I see Representative Lawrence making eye contact with me. Do you have go ahead, Representative Lawrence.
Thank you, Chair. I didn't know if you had others in the list or not, so
You're first.
thank you very much, Chair Jordan. Representative Green, and I just have some knowledge questions, just kind of digging into this and ask some questions for background information. I come from a township background. We were free to set how we wanted to handle this. We spent a lot of time just setting our policy, what we would charge, how much we would invest, who was going to request, how much time the staff would invest in this process. We knew we had to give the data out, but we set the guidelines. Are school districts or school boards not allowed to set their policy? I don't see that dealing with this here, but my first gut says they should be setting this policy, not allowing the requesters to set how they handle it. And maybe that's my first question. Do they have that authority to set the policy and how they administer the data requests?
Representative Green.
Yes, thank you, Chair, and thank you, Representative Lawrence, for the question. Great question. I served as the policy chair on the Edina School Board, so I looked over our data request policy many times. So the answer is yes. School districts set their own policy, and a lot of times it is based on model policy received from the Minnesota School Board Association. That's where that comes from. I think where the issue has bubbled up, though, is how complex the data requests have come, and typically, I think it has been more specific, and most people, before when data requests would come into a school district, you'd show up at the school and you'd go and look through the files and inspect the data and say, okay, I want 7 copies or a copy, these 7 pieces of paper copied. So there really wasn't an anonymous issue going on. It's kind of a byproduct, I think, of the digital age that we even have this issue. And so, Yes, the short of the answer is yes, districts can do that. And one of the things we've talked about a lot is how do we provide that training? You know, as Rich Neumeister said, you know, this has been, the Data Practices Act has been around for 50 years. And so to keep up with that training, I think is something that is absolutely essential. I think it will bring down a lot of the attorney fees that we're seeing with districts. So I find this bill as a both and. We need to be doing both. But I like that we have something in statute to just give more guidelines to that policymaking.
Representative Lawrence.
Chair Jordan, thank you. Representative Green, follow-up question. You mentioned anonymous, because I find that surprising that a school district would automatically respond to an anonymous request. Is the school board required to respond to anonymous requests?
Representative Green.
Yes, thank you, Chair. Yes, they need to reply. And you know, originally when we first started talking, I went in and was like, you know what, let's get rid of anonymous requests. And in digging into that, I had that wrong. I think that's wrong. I think that there are situations where parents, families, or employees need that protection. And not that there would necessarily be retaliation, that's against the law. However, you know, if you were a parent and you wanted to do a data request on a coach, you can imagine what that would be like if that was public for the kid, right? I mean, that's just kind of unfortunately how things are. And so, yes, for sure, I appreciate your question, and hopefully I answered it. Okay.
Representative Lawrence, any further follow-up?
Yep, Chair Jordan, one small follow-up, because you mentioned a coach, Representative Green. My understanding that any teachers or educators or personnel data would be private. Can an anonymous individual request a private information about a teacher or coach or staff?
Representative Green.
Thank you, Chair Jordan. I'm going to pass this off to the expert sitting next to me.
Mr. Ealing.
Thank you, Chair Jordan, Representative. There is a section in the Data Practices Act called the Personnel Data Section. It's 1343. In the bulk of the Data Practices Act, the presumption is that data is public, unless there's a specific provision that says it's not public. In 1343, that presumption is flipped for government employees. So there's a list of public data in there that includes things like name, work phone number, if there's been sustained discipline, so those files would be available. But the bulk of what an employee does in their employment capacity that's held by the employer, the government entity in this case, would be private. Now, the things that they do for the government entity generally become public. So, you know, emails about policy or the work product that somebody produces for the government entity would be public, but their employment-related details are generally private with certain limited exceptions. Thank you.
Great. Yep. Thank you, Representative Lawrence. Next on my list is Representative Mueller.
Thank you, Chair Jordan, and thank you, Representative Green. I will say that before I came here, I did have a conversation with Representative Scott, who wanted me to just kind of ask some of the questions. And I'll be honest, as I'm still trying to understand this issue, can you or your expert here kind of explain what it means to provide data on a rolling basis? That's my first question, Chair Jordan.
Representative Green, would you like to try that, or should I go to Mr. Ealing?
Thank you, Chair. I'll try and respond to that.
Okay, go ahead, Representative Green.
Okay, thank you. And, you know, I spoke with Representative Scott about that, too. I appreciate the question, Rep. Mueller. And, you know, it is already in law. Like, you're already able to do that. And so in an effort to try and give some more guidelines in statute and how districts can respond, that is why, and from feedback from districts, that's why I put it in. However, looking back, I've looked at this over the last 24 hours over and over and like tried it and looked at feedback that I've gotten from, you know, our Minnesotans for Open Government as well. And I think actually the way the statute works, if we were to strike that line, I think I think the bill would be as effective. And so that's my response, unless I got that wrong.
No, that's our sense too, Representative Green.
Thank you, Representative Green. Representative Mueller, follow up.
Thank you, Chair Jordan. Yeah, from the sense that I got from Judiciary was that that rolling basis was in rulemaking, but it wasn't in law. And so there was concerns about putting that into statute. And so, which again, data laws are so complex and craziness. And so it's really good to try to be as specific as your testifier has talked about as well. So that, I just wanted that clarification, Chair Jordan. And so thank you, Representative Green. It seems like you've been doing a really good job with the bill, so thank you.
Thank you, Representative Mueller. Next on my list is Representative Falconer.
Yeah, thank you, Chair, and thank you, Representative Green, for bringing this forward. As I'm sure that we all have been in talks with our school districts, there's some financial troubles, if not now, on the horizon. And I've talked about this with board members, superintendents, and who are appreciative of the work from my district as well. So just from your example of 6,000 times 4, I mean, that's $24,000, 400,000. I mean, we're talking about money that could go toward teacher salaries, para salaries, support teachers, or support staff, programming, whatever it is that's being thrown away on these fraudulent asks or the repetitive asks, whatever your term was. So just thank you. I think this does help go toward solving a problem that is desperately needed, as well as the benefit of saving money that school districts at this point desperately need. So it's really just a comment of thanks and appreciation.
Chair Bennett.
Thanks, Madam Chair, and Representative Green, thanks for this. I really appreciate how thoughtfully you're approaching this, listening to all sides, and I mean, it is a problem that needs to be solved, but solved carefully, because we're dealing with public transparency, and we're also dealing with fiscal responsibility with tax dollars, so we've got to find that sweet spot. I appreciate how you're seeking that balance, so thank you.
Yes, thank you, Representative Green, for some real yeoman's work on this. And thank you to all the advocates that have been very thoughtful and helpful too, especially thank you to Mr. Neumeister and Mr. Ewing for all your help. And just as a reminder, members, this was an informational discussion. I think we all agree that we hope Chair Scott and Chair Liebling will give this a consideration it needs in the Judiciary Committee. So thank you, Representative Green. Any final words?
Yes, thank you, Chair. I just want to really thank the partnerships that and the relationship building in making this work. This is when I ran, I heard this a lot from different school boards. It's an issue, and we need to figure. I just love that we're getting to this point where we can give districts some more training and a little bit more so that we can manage this better, and we don't see just money flying out the door, because that I think makes all of us a little angry. So thank you.